very good evening to all of you and a warm welcome to another episode of Law and Order on Channel I Rupavahini. And today for our segment on Law and Order, we are more than happy to welcome Mr. Prashantalal Dialvis, President's Counsel, a visiting lecturer at the Faculty of Law, University of Colombo, Appit Law School, and Sir John Kothalavala Defence University. And a very good evening, sir, and a warm welcome to Rupavahini.
Good evening.
And today, we are going to focus on something which the Sri Lankan general public lack awareness of, aspects of criminal law. Now, there are instances where people are subject to arrest, sometimes people are subject to questioning by the police, sometimes people are requested to come to police stations for different allegations of criminal offences, and most often people do not know what rights they have and what is the procedure. And therefore, people are subject to violations of their rights, and people are subject to different inconveniences as a result. So, my first question to you, sir, is now criminal law is a wide spectrum, and the first thing which comes to a person's mind when we talk about criminal law is the police. Can the police arrest a person for any offence?
It is not only the police. If you are committing an excise offence that is relevant to excise ordinance or forest ordinance, still they can arrest you. But then even electricity offence they can arrest you, but then you have to be given to the police. So arrest means you touch a person and you stop that person's movement. Now I like to stress here the most paramount thing in Sri Lanka is the fundamental rights in the Constitution. Constitution is the most important law in this country. Now that recognizes fundamental rights. Freedom of movement is one of the major fundamental rights of our country. Freedom of moving wherever you like to, any part of the country, and that kind of restriction. But of course there can be restrictions like what is happening today. I came into Rupavahini, I have to show all my credentials, why I am here, otherwise I would be prevented coming. But other than that, the freedom of movement is the most paramount, one of the most paramount right a human being has as a fundamental right. Now arrest means the first point that is restricted. And from the custody, it goes to the police custody. And now that's the important point. So with the arrest comes, you have to produce before the magistrate. Now that is judicial custody. The judges may remand you. That means remand is because judge can't keep the accused at home, no, right? Otherwise, concept is that judge is keeping in his custody. Therefore, judges, the clear word is not jail, but remand it, so that it is in his custody. So this is the process that takes place, and that restricts freedom of movement. So it's not only the police, generally the police does it. Now the important thing in today's context is now who can arrest? Can the army arrest?
And that's a question, I think, especially with the new emergency regulations.
Exactly. That's what the Army Commander has been always saying. Now, unless there is emergency regulations, there is no right for the army to arrest. That's what they are seeking. That's what it has to be given, because only the police has a right under the Code of Criminal Procedure Code to arrest. Even army, you would see in the recent past, when they arrest, they have to be given to the police, because we have to understand and appreciate it is the police who is handling law and order. And that is why it is under a different ministry. It is under the president, because law and order is handled by the police. So that's a simple concept. Army, Navy, Air Force, Civil Defense Force is to protect the country, whilst the police is the main paramount job or the duty is to preserve law and order. So it is the arresting power is generally with this. Even electricity board, you are violating the Electricity Act. Still they will arrest, and immediately they have to go with the police officer. If you are arresting a person, electrical officers has no right. But of course excise ordinance, say that has to be given the right, forest ordinance, and they are given rights to arrest people in that kind of a contest. Even like customs, you would see when a person is brought in, there is no police officer then and there. So the custom officers will arrest you at the airport or the harbour and then hand over to the police. So that's how the arresting system works in this country.
And also, once a person is arrested by the police, how long can that person be detained in police custody? And what rights does the person have? Can he contact other people, or can he request for any special privileges at that point where a person has been arrested for offense?
Yes. Now, when you are arrested, earlier law was it was 24 hours. You have to submit to the judicial custody that I mentioned before.
So you have to produce him before courts within 24 hours
Exactly.
from the time
Of arrest.
his movements were restricted.
Imagine if there is a case in Colombo and there is a warrant. We'll take a warrant against him to be arrested. And the man is arrested in Badulla. He will be brought to Badulla court because you can't bring him to Colombo within 24 hours. Maybe not. And therefore, he will be surrendered to the nearby courts. So likewise, that is a guard, so that police officers can't hold it. So, but then we find most of the time they are not arrested, they are kept in the police station. You will see that scenario. They don't record you as a person who is arrested, but they are held there. And therefore, technically it cannot be they will question, but they will not arrest. Because I like to stress, the word arrest means you are supposed to touch that person and say you are under arrest. Now you are not free to move. So until then, even in police, even in some place, if the police can question, it may not be amounting to arrest. And I want to stress, if it is an illegal arrest or illegal detention, you can file a fundamental right application. And that has to be filed within 30 days of such illegal arrest or detention. But sadly, it is only can be filed in the Supreme Court of Colombo. Even a person in Jaffna or Matara or any part of the world, country, Sri Lanka, has to come to Colombo within 30 days to file a fundamental right case if you are illegally arrested or illegally detained.
And also, what privileges after a person has been arrested? Can he contact his family, or can he contact his lawyer, or is he not allowed to communicate at all during arrest?
He's not allowed to communicate at all, because you have to understand that process is for investigation. Because moment you arresting is a very interesting phenomena, because it can be done by the officer in charge of that police station. When there is a reasonable suspicion, the word is reasonable suspicion, OIC can arrest one if that is committed any offense. So with that comes investigation part. Now when the investigation is on, Sri Lanka law, and I think even for that matter, any law, prohibits him having any contact with the outside world. So therefore it is not prevented. But then we are at least seeking a lawyer to go there, but we will always make sure that a lawyer goes there, because there is always allegation that he may be assaulted in the police station in order to get a confession out. And therefore we lawyers would go and surrender that person to the police station, so that to prevent him of getting him assaulted. So that's the only safeguard you have. A lawyer even can't stay on while the investigation is on, or the questioning is on, or the recording of the statement is on. Only he can hand over the accused and get out.
And thereafter, once a person has been handed over to the judge for judicial custody, what process takes place after?
Certainly. It is very simple. Before that, Shara, in the police, generally minor offences you can get bail.
By the police itself?
Police itself, like the excise ordinance, like if you have illicit liquor and all that, you are not arrested and brought before court, because those are very minor offences, traffic offences most of the time. When you are brought in, you will not be, you will be given bail. Good example, even if there is no accident, the drinking, driving, you might not be produced. So, but then question is that you will get police bail. You have to sign a bond saying that you would appear on a particular date. But other than that, basically our law is governed by Bail Act. It says giving bail is the rule. That means court must give bail, because we find that's a concept with a lot of people in remand without getting bail. So the law is getting bail. Now, there are so many we can discuss, so many aspects of bail on that, but generally we call it cognizable offences. Is the one where you can arrest without warrant. Now, there is bailable and not bailable offences. Non-bailable offences, generally magistrate has to grant bail, unless investigation can be hampered if the accused is out. Good example would be like, say he has committed an offence, fraud in a bank. Now, if he is out, he can go and influence that investigation. So then therefore court may...
Or destroy evidence.
Destroy evidence, beautiful, yes. and therefore he may be restricted going out. And other one is if he has committed past offences and there is a likelihood of him committing more offences. To prevent such offences committed, then still you can hold him in. And the very interesting one, refusal of bail, is public disquiet. Because we get him out, there can be a public outcry, public protest. Then the police will submit that facts to the magistrate. And those are the few grounds that under section 14 where the bail can be refused. Other than that, the rule is the bail is granted. But there are so many other offences which we can answer where the bail magistrate do not have powers at all to grant bail. It has to go to a different courts.
And also, sir, now when we talk about granting bail and then producing a person before the magistrate, thereafter, if a person is remanded, for how long can the judge remand him for? And thereafter, what is his privileges?
Yes. Now, remanding happens because those reasons that I gave. Now, there the judge must give reasons. Now, but there are certain other laws where the magistrate cannot give bail. Good example, archaeological aspects of things, right? I mean, that kind of offense, there is no bail. And if it is poison and opium, that is heroin or that kind of offences, you have to go to the high court, not the magistrate court, and show exceptional circumstances in order to get bail. And if the offences is against public property, that means if you destroy, mischief, rob or whatever of public property, which of a higher value, then you don't get bail unless in the same court you show exceptional circumstances. I like to stress the word exceptional circumstances. So in that kind of a context, the getting bail would be difficult. Why? Because difficult, you would see those offences are little grave. It has a social impact, it has a legal impact, it has much more grave offences. So therefore, they make you to show exceptional circumstances like the Poison and Opium Act and even the offence against public property. So the judge will therefore have to remand the accused. And remanding every 2 weeks, generally the court will remand, because then every 2 weeks he is brought before court. Because you can't remand him unless there is an urgency where the court may remand him for 1 or 2 days, unless they allow the police to come up with certain facts to prove that their assertion is right. So it all depends, but he will be remanded, and that is judicial custody.
And also, along with that question, now there are so many reports on media, social media, and there have been reported instances where during remand custody and during police custody, people have been subject to torture, people have been subject to assault, people have been subject to sign documents which they do not agree to, and also situations where different bribes have been solicited by members of the police. Now, in such a situation, if a viewer is subject to such a condition, what remedy does he have?
Of course, he is tortured. There have been many cases. Immediate thing would be to go to the government hospital and get the JMO to inspect on you, because that's the only evidence you have. Some physical external injuries if you have, certainly you must go to the hospital, the closest nearby hospital, moment you get released. Or even you can make a complaint to the first opportunity to the prison authorities. And as I said before, you have produced before the magistrate. And that is the place, that's the opportunity where accused can come out with. Unfortunately, unless you retain a lawyer, you may not come out with it. So generally they produce the accused in the magistrate's residence. So there may not be a chance, but you must give that complaint in the first opportunity. Otherwise, you pursuing a torture case in the fundamental rights, as I mentioned. Torturing is a fundamental right violation. As a constitution, you can prevent all the other, freedom of movement can be prevented for so many reasons. But torture, for no reason, a person can be tortured. Because sadly, I have to say this, with the limited time the police have, they have to get all the evidence in. So that limitation of time is the factor. I'm not justifying what police is doing, but when you say 24 hours, you have to crack the accused and get ahead and find the dead body. You can find that all these.
Crack the accused, not physically.
Not physically, exactly. What I meant was like mentally cracking the evidence and accused and getting the truth out, so that the investigation can proceed, so that dead body can be found, weapon can be found, and the witnesses can be found. Those can't be generally done in 24 hours. So therefore, that's the reason why there is a tendency for the accused to break it. But therefore, they need a change of law, where I believe he should be immediately produced before a magistrate and allowed to stay on there for about 4 or 5 days in the police, so that he can't be physically touched. So immediately forthwith, I believe that he should be produced before a magistrate. That needs reform.
And in the event where a police officer solicits a bribe, can you take immediate action regarding?
Certainly, only the bribe is handled by the Bribery Commission and the Bribery Department. So you have to contact them, and you can trap them. I mean, if you want to. Because recently you saw 2 police officers for a bribe of wild boar. They had taken a bribe and got convicted in the Colombo High Court. So there is that kind of a situation happening, and you can always go to the Bribery Department and get your relief. Even trap it. I mean, while giving it, you can trap him giving the bribe.
And also now after arrest and remanding a person, next of course would be the trial stage, where
Yes.
a person would be charged at the magistrate's court or the high court depending on the offence. How does this procedure work?
Yes.
I know it's a very long procedure, but in nutshell, how does it work?
Now, as I said, if it is a reasonable suspicion, you are arrested and you are called a suspect. Then investigation proceeds. That's in the entire hands of the police and the investigating arm, the Attorney General, the government analyst, examination of question documents, the doctor's post-mortem, everything comes into play during the investigation process. At the end of the investigation, there will be a charge sheet. And in the High Court, we call it indictment. That's a high up, because the High Court, the Attorney General himself signs the indictment, because it's a grave offence. Death sentence cannot be imposed by a magistrate, so it will end up in the High Court. Now, that stage, he will be called an accused. He changes from suspect to an accused. So when the accused pleads guilty, he will be sentenced. But for a murder case, you can't plead guilty. That's the only offence that you cannot plead guilty. The trial will still continue if you plead guilty. But then, in the other offences, the trial will proceed. Evidence will be led according to the rules of evidence. And at the end of it, either you are convicted or you are acquitted. Acquitted means you are totally out of the case. But in between, if there are no witnesses and if the prosecution is not prepared, you will be discharged. So that within 1 year, the prosecution has to file a new case. And if they don't file, it amounts to acquittal.
And also now, that brings me to my final question for this episode. Now, the final outcome of a criminal trial is either the accused will get acquitted or he might be punished. So punishment could be either imprisonment or a fine. Now, the purpose of criminal law is to prevent crimes from taking place in society. And you being a criminal lawyer for many years, for many decades, and going through so many cases and trials, are you happy with the current system of criminal justice in Sri Lanka, where a person is sentenced to jail? And do you see that forms a deterrence in society? And secondly, is it a good place to rehabilitate such a person?
Certainly. I've been a state counsel for 7 years, from 83 to 90, prosecuting. So I have sent people for death sentence and jail. But then I've been now defending people. Actually, the sad part is the delays. Say a murder case, the trial is taken up after 10 years sometimes, or even 20 years. By that time, the man is grown, married, and things like that. So the deterrence after that, a death sentence, it doesn't work. And I must confess, at that point in a village, sometimes people get friendly. They get intermarriage. And sometimes witnesses go back. So the justice is not done. So because of the delay, right, this doesn't work. And especially I cannot see a deterrence when a person is sent to death sentence, but actually you are not hanged. I'm not saying the sentence should be done. So you can see the accused with a V shape and going very happily outside with a death sentence. So that can't be called a deterrence. That's what is happening. You take a newspaper or TV news. After death sentence is passed, people are jubilant. I mean, they don't fear, or face does not resemble or show any fear. So there is no deterrence in that system. So actually the sentencing is, as you said, is a deterrence to you as well as society. And that is not working efficiently and effectively simply because the delay that we have.
And also, one of the purposes of any criminal justice system is to correct those who do wrong and send them back to society. Do you see that happening in Sri Lanka?
If it is a first offender, certainly he has to be rehabilitated, because it can happen to you, it can happen to me, it can happen to you. So I think rehabilitation has to happen, and that has not been successful, because that's the concept is suspended sentence. The first offense, you don't send him to jail, you are suspended sentence unless you commit the second offense. So that is there, that is working well, but then still there is no rehabilitation of a person, a system in Sri Lanka, where your mentality, your whole thing, you are castigated by society as a criminal moment that you are in jail, and that's the end of your life. Even in remand, people put in remand, a young boy, he will come out as a criminal, because you are associating with that kind of people. So that total even remanding creates criminals. So I am not happy. I cannot say that outcome has come out.
So the exact objective of rehabilitation might not happen to the expected level in Sri Lanka.
Absolutely, it's not happening.
Okay, so with that, we conclude today's episode on law and order, an interesting discussion about aspects of criminal law and how the criminal justice system works in Sri Lanka and whether it achieves its objectives. So once again, we would like to extend our sincere thanks to Mr. Prashantalal Dialvis, President's Counsel, for gracing this occasion at Sri Lanka Rupavahini. And again, we wish you all the very best, sir, for continuing to inspire young people and young lawyers and the general public, especially in your teaching career and also in your great work you do to society. So once again, we would like to meet you with another episode on Law and Order next week at the very same time.